Welcome back and thank you for staying with KTN Prime. Now I want to dive into a conversation about the Kenya Information and Communications Amendment Bill 2025, which was brought before Parliament by Aldai Member of Parliament Marianne Kitani. She says it seeks to safeguard the economic interests of internet users. But as you're all aware, the devil is in the details, as they say. So we want to dissect what exactly is in this particular bill. And feel free to be part of the conversation. There will be a number scrolling on your bottom of the screen. And you can always call in and be part of the conversation. After all, it affects all of us. So joining me for this particular conversation, to my far right, we have Kennedy Kachwanya, who's the chairperson, Bloggers Association of Kenya. Good evening and karibu sana.
Good evening.
Next to him, we have Dimas Kiprono, Deputy Executive Director at the International Commission of Jurists, also known as ICJ Kenya. Karibu sana.
Thank you for having me.
All right, so I'll start with you, Kennedy. I mean, when you got hold of that bill, what was your immediate concern?
Censorship.
Okay.
Yeah. You see, when you look at the bill, the first thing they're talking about the meter billing for the ISPs, that is the internet, the internet providers.
Yes.
But the bigger problem goes when you move forward. Then they're saying that the content you consume should be in a readable format. Now, ISP at the moment knows the content, I mean the amount of data I consume. So if they want to bill me, they will know that. So that's not a big problem. But when you start saying, now whatever I consume be in a readable format, what you're trying to say is whichever website I visit should be such that it's readable given to the Communication Authority, which of course in the first place is against data protection law. But another big concern for me is where they are talking about the domains administration, so .ke domains.
Yeah.
So they are saying that all the registration for .ke domains should be licensed by Communication Authority of Kenya. Now, usually the domains, the way it works, is first come, first serve. So if I look for domain kachwanya .ke, I should get it, and I should not go to another body. So KENIC, that's the body that registered the domains in Kenya, should register me, and that is it. So I don't need to go to another body to give me a license so that I can use my domain.
Okay.
When you go to that region, what they're trying to do now is to control the content creators. And that's why the censorship, which I started by saying censorship.
Okay.
Yes.
All right, I get you. And just staying on the same note, I mean, we already have the Kenya's, the Data Protection Act, yeah? And here we are, of course, data protection concerns are being raised. So then, what are the privacy implications if we go down this route?
Well, first of all, the law or the bill, when you look at it, it declares that it does not limit any rights, which I think is patently false. It limits right to privacy, limits freedom of expression. And the way it is worded, it flies in the face of data protection principles. So for example, principles in the lawfulness of the data you're holding, data minimization, meaning that you only need the data, you only store the data or process the data that you need and not for any other purpose. You understand? So here, the bill purports to be enforcing consumer rights. But when you're telling internet service provider to give a unique meter that is attached to your name, your number, your gender, and then ask the ISP to further store that data in a way that it's readable to them, it means that they want to be able to access the right, I mean, the content in which a person's internet activity is about, and which is very problematic. Another thing is, under the Kenyan Constitution, when you want to limit a right, you have to follow certain guidelines. So for example, a limitation must be lawful, right? It must be concise, it must be clear, right? But another thing is that it must have a legitimate aim. Here, the legitimate aim they claim is consumer rights, but we see that it's a little disingenuous. Number 3 is that any limitation must be necessary and proportionate.
Okay.
We find that this is not proportionate. It is wholesale taking data for no purpose. And even before we had the Data Protection Act, by the way, the Prevention of Terrorism Act requires the police to approach a court to get a warrant before they can be able to look into your private things or do surveillance. Here, the law seeks to blanketly have access to your data without you doing anything. Usually there needs to be probable cause if your rights are going to be infringed upon, and here we see none of that.
Okay. Coming to you, Kennedy, I mean, the issue of metering.
Yes.
Is it the most ideal means of enforcing accountability and perhaps tax responsibility in the country? Is there another way we can go around it?
The other ways, the current way they're using is still okay. I mean, there's no problem with it. If you're saying you want to increase my right to enjoy the internet, then what you need to be going after is what, for example, if an SP promise to get me like 30 MBs in a certain duration, and that is already there. If Safaricom or Airtel or Telcom say that, that is already there. So there's nothing there that they are trying to achieve with this. The main aim is the readable format thing.
Okay.
Because that's, to me, when you look at it. And then also there is a point where they are saying you must, that data, ISP must give it to authority, in this case communication authority, for any legitimate, they say, functional authority or functional work.
Yeah.
So it's anytime ISP are asked by communication authority, they will give you data.
Yes.
Because the law already indicates that. And to me, that is very problematic. And the metering thing is just an excuse. And first of all, look at KPLC. They do metering thing. Does that improve their services? If they do, if it does for you, maybe mine it's not. Yeah.
Okay.
So
you want to add on to that?
Yes, I think overall, when you look at these measures, so for example, in the finance bill of this year, there is a provision that would give KRA the right to bypass data protection principles for purposes of tax collection. There is another amendment to the Kenya Communications Act that is being proposed that is supposed to ensure that everyone using social media get in through an ID number. And so clearly you are seeing that there's an infrastructure that they're trying to build, a surveillance infrastructure to be able to monitor people's communication online and online. Mind you, these days, most people's communication is digital. Whereas before you'd go to the market, there'd be someone shouting, or you'd read newspapers. These days, you get your newspaper online. Most of the things you get digitally. And so they want access to this digital activity of yours, which is actually your right to seek, receive, and impart information and ideas, which is a fundamental right that should not be infringed upon lightly. Yeah.
Let's talk about that. I mean, imagine having to register an account on Facebook, on X, or on Instagram, and giving your details, your ID number, your postal address. I mean, how sure are we that this data is actually safe? There's also that. Is there any provision on that?
So there is a provision that requires the ISP and the Communications Authority to keep the data in a confidential manner. But we know what happens. And also, data is always vulnerable to breach. And in fact, in most cases, countries are encouraged to silo data to ensure that data are kept in different storage spaces so that at no point can one person swoop in and get all the data about a person or so on and so forth. Here, they will have your data, your gender, your intimate activities online, what you're searching for. And if, this is very private data. that no one should be able to have. And in case there's criminal activity that perhaps they are looking for, you know, when you're talking about free speech, for example, the right to seek, receive, and impart information, they say that it does not extend to propaganda for war, incitement to violence, hate speech, advocacy for hatred. You understand? But already we know that the government has the tools to locate a person, even if they hide their identity, that they have the tools to locate that. So why the need to have all this data in raw, ready form, ready to be read by anyone? Yeah.
Kennedy, coming to, I mean, if it's all about ensuring that there's no hate speech online, as he's mentioned, there are various ways of doing it. There are various ways of the authorities that we have in the country to just sort of zero in on someone. I mean, we've been seeing it happen in the recent months. But from our content creation perspective, what is the ripple effect of all this? Because it affects some people whose livelihoods are dependent on content creation. Where does that leave them?
I mean, it's a dangerous, it's a dangerous point to go to. And for example, the hate speech. You know, Demas, who is a lawyer, will tell you that it's well indicated on our constitution, and there is also acts that cover the hate speech. And there's a thin line where I say something you don't like, and then you immediately say it's hate speech or misinformation or something like that. And in most cases, if it is something that you say, okay, this person is saying things which are not true about myself, the law provided for that, defamation. So you need to go to court. The problem with our leaderships, these MPs and executive, they want a way that somebody can be arrested and thrown into jail without due process for what they say. Now, the due process become a problem to them, and now this is the point of coming up with these different laws, because they don't want to go to court straight and say defamation. Because in most cases, what people are saying are true. So if you are talking about corruption, it's true, but people don't want it to be that to be said. Yes. So the people in authority are trying this such that it's an intimidation tactic. Over the years, there are laws that are being used and be declared unconstitutional. For example, criminal defamation, the use of gadgets, misuse of gadgets. So there are a number of laws that the authorities have been using. But you realize that so far, in a few cases where people are arrested publicly, the content creators, they end up not being charged. Because sometimes if you go to discovery, you know what they call in court discovery, and now I start going after what I was saying, and now you have to prove that it's not true, you give the document, that is the point that the people in authority might not want. So they want a situation where you are saying you are a criminal against the state, you are thrown in, and not to go to the process of proving that whatever you are saying is true.
Okay. And we'll continue dissecting some of these issues, but I want us to draw examples from other countries. I'm aware Tanzania and Uganda have way more tougher laws when it comes to digital content creation and social media in general. But is there any country we can draw reference to that actually has a law like this that is actually working well without infringing on human rights?
So as you put it, Uganda and Tanzania have a very restricted cyberspace. You know, for you to run a blog, you have to register, and you're responsible for what is on there. There's taxation, for example, of social media in Uganda. Kenya has a raft of laws that govern freedom of speech. However, we see that the government or the people in power, and I'm talking about, when I say the people in power, I talk about the political class. Because if you look at how these laws have been coming to bear, so in 2019, there was an amendment to the Kenya Information and Communication Act that was proposed that required every admin of a page or even a WhatsApp group to register, and then you are to be responsible for what people are saying in your in your platform.
Yes.
Yeah, and we went to Parliament and successfully convinced them that this law was unconstitutional. And even as we look at this bill, the way it is authored, the way it looks like now, it is ripe for a challenge in the law, in the High Court.
Okay.
The High Court over the last decade or so has been very progressive in terms of freedom of expression. So, for example, as he puts it, criminal defamation was found to be unconstitutional. Why? The judge in that case, Judge Mativo, said that the prospect of a person being arrested, having to raise bail, having to look for a lawyer, and then going through the criminal justice process because of something they said about someone else is unjustifiable. It's not necessary, it's not proportionate. And so it fails the three-part test. Then there was another law called the Misuse of a Licensed Telecommunication Device, which was also used a lot against journalists. The court said that the words used in that law were vague. You understand? So if you send something over a licensed system, so a phone or so on and so forth, and then it causes someone anxiety. The court said, what does causing someone anxiety mean? That is vague. It is not, so it doesn't mean the legality test.
Yeah. Okay.
Right? And then there was a tweet by Alai, Robert Alai, about what President Uhuru had said about Raila Odinga. He called him an adolescent president. And then he was charged under undermining authority of a public officer. Yeah. So first of all, how do you undermine authority of a public officer? Did he cease to be president when Alai tweeted that? But then when that was challenged in courts, the court said that a citizen of a country must be able to criticize a person in power. And that was found to be unconstitutional. But during that ecosystem, there was a time that members of parliament felt that Kenyans are talking too much about them. And if you look at the Hansard at that period, you'd find that when the Cybercrimes Act, the Computer Misuse and Cybercrimes Act was being passed, MPs were saying, tutaonyesha waache kuongea kutuhusu.
Yes.
Right? And they passed the Cybercrimes Act, which contains Section 22 on publishing false information, Section 23, false information or false information about a person or causes dispute to a person, which is actually a sneaking back of criminal defamation, and online harassment, 27. But if you look at the laws, the wording is also very vague. But the biggest surprise about that law is that the range of penalties. So under 22 is 2 years in prison or 5 million fine. Under 23, it is 5 years imprisonment or 10 million fine. You understand? Yeah. That to us seems like overkill. It seems very stringent, and we are in court trying to bring that back because our political class tends to be able to speak to each other. Actually, right now, if you look online or if you look at our media, they are insulting each other day and night. But the line is drawn when a normal person or a blogger says something about a politician. That's when it becomes a criminal issue. Yeah. And we want equality before the law.
All right. Before we come to you, Kennedy, I understand we have a caller. Kiprono from Nairobi is calling in. Good evening, Kiprono. What is your contribution to the discussion?
That have been raised according to the bill.
Yes.
Is its potentiality to be used against the people of Kenya in terms of tracking their whereabouts, cyber security is concerned and everything. And I think it's not a good legislation, especially now that we are speaking about, as a country, we should be talking about other issues of concern. We should be talking about the state of the economy. We should be talking about other issues that are more trying to feel and say because Kenyans have to have a piling address for their internet and everything. It's not an area of concern right now. But with the nature of our political class and this coming from the ruling party, I think it shows how the government can be insensitive to the plight of the people of Kenya. So, as the young people of this country, we are also expecting to see the time it will take. And then, of course, many times we might move to court we might also come out and protest if we feel we're not satisfied with the same law. But I think it's not something that should be given a priority at the moment.
Thank you so much, Kiprono. That is, he's calling from Nairobi. Kennedy, coming to you. I mean, what he's saying is actually valid.
Yes.
There are so many issues happening right now in the country. This is the last thing we expect. But it also speaks to the wider picture of where we've been hearing critics criticizing the government and saying that, you know what, authorities and institutions are being used for politics. What is your response to what he's saying?
You know, the internet is a great thing, and there are so many areas within the internet space, especially the digital economy, that if you're an MP, you could do to improve the lives of Kenyans. Because at the moment, there are many young Kenyans who don't have jobs. And in that case, you can improve that by looking at those legislations, but not trying to target communication.
Yeah.
And that's why I agree with the Kiprono that it doesn't make sense. This is not a priority. There are many issues, and if the job creation should be the issue, then you should look at it that I want to create a job for the young people. I want to look at the IT space on how to create a job for young people, which should be the priority of any MP that's trying to look at ICT. But if you are concerned within ICT, and I don't know, but it's my thinking that the bill might be, the MP pushing it might just be a face. That is somebody else behind there that pushing that. Because the reason I'm saying this, in the last few months or few weeks, you have heard about this call of regulate social media from many prominent politicians and other Kenyans on the authority. And so when you look at that, and when I look at this specific bill, I see the signature of some of those people talking out there.
Okay.
Yeah.
All right, well, just to hold that thought, let's just take a short break. We'll be back with more. So, from where